So we are live. We, whoever that we is, I know I am. I'm live. I think I'm here with 808 JCB3, and thank you for joining me wherever you are. If you're on the Pacific Coast, and that's great. If you're elsewhere, that's wonderful. Maybe in Europe, they might see this in the morning hours. That might be a difference. I wasn't really planning on doing a live stream, but why not? I was sitting here and I was thinking about so I'm talking about GTII before I get into it. I was thinking about, the last couple of documents that the receiver has filed, that being that fourth interim report, and then the motion and objection that they filed that we talked about, where the 87 people purportedly received shares, illicit shares, under dubious circumstances. And then I was thinking about the audit, and one of the persons who didn't sign the audit, apparently, or the certification, apparently per the receiver's documents, was one of the attorneys, Jack Fatel. I think it's Fatel, that's how you pronounce it. Fattal. I know I spoke with him and I called him Fatel, and if I mispronounced his name and he didn't correct me, and I'm problem, I apologize for that, Mr. Fatel. But I did speak with him, and since he didn't sign off, or apparently had not signed off on the audit, it made me think about how this started and how easily GTI management could have navigated around this, but for whatever reason, and I haven't quite figured out the reason, they navigated themselves into this position. So I quickly, before we start the new week with court hearings and everything, I wanted to lay in perspective how I got involved in this and some of the discussions we had. And I'm looking at some emails and a couple of letters. This is some of it that relates to it. And of course, before we start that, obviously, this is not legal advice. Please like, subscribe, share, comment. I've been getting a lot of comments. I appreciate that. If I don't respond, there may be a reason why I don't want to respond. But I appreciate everybody's comments and everybody's opinions, and I look at everybody's, just so you know, I do look. Just a couple things before we get started. What is a vampire's favorite fruit? Of course, a nectarine. Who doesn't know that? And, I stayed up last night wondering where the sun went. Then it finally dawned on me. And last but not least, I told my wife that she was drawing her eyebrows too high. She looked surprised the entire night. Think about that one. Anyway, so we're gonna go back in history a little bit, back to the end of 2023, beginning of 2024. That's old history. So I had spoken to a bunch of people. A bunch of people were just talking about GTII. For whatever reason, I had contact with several of them. They all kind of repeated stuff that's made it sound like GTII, something was up with GTII. And before I go ahead, I just want to appreciate everybody who's here. So I'm just going to call it off. I already announced 808 JCB3, Darren Collins Scott, 22 J Dog. There's 808 again. Thomas DuBois, Tebow Alex, 22 J Dog. There he is again. Edgardo Spana. I like that name. Deborah LeMay, Toe Cramp. I like that one very much. Anyway, thank you for joining me. And whenever anybody watches this at a future time, future day, during the holiday, I think this is perfect Memorial Day fare, honestly. So anyway, so a bunch of people are talking to me about at end of 2023, including JR, the JR, and who was at a Metallica concert with his son, and I think his son really enjoyed it. That's nice to hear. I enjoyed that, hearing about that. And something just didn't seem right. And so I'm listening to this and I'm deciding how could I deal with it. And I said, why don't I just reach out to management and basically give them an opportunity to prove all the people that were claiming there were some kind of shenanigans going on or whatever, deals not being closed. Heard a lot of deals not being closed. Heard a lot of stuff generally. And again, as I sit here right now, I haven't looked through all this stuff, so I'm just kind of like thinking generally. But there's just stuff that didn't sound right. But that's what a bunch of people are saying. So, do I know that for a fact? No. And am I, skeptical or whatever everybody says to me? Yes, of course I am. So what do? I start reaching out to management. I think I reached out several times, but I don't remember that. But when I refer to a document, then it references that I did. But I don't remember who specifically I did and how many times I did. But I know I did reach out many times. I reached out at least to the address, the email address. I probably called, left a message, but I don't remember specifically. But I'm pretty sure I did. Maybe probably more than once. And I sent a bunch of emails or an email to email addresses that were associated with David Reichman, Kathy Griffin, Warren Moskowitz, Jack Fatel. Not always that group, but including that group. And I got some replies back from Fatel, so I know that they were received. And I know at one point in time, I had sent I don't think I included Fatel on an email. Yeah, I do remember this. I didn't include Fatel on an email. It was only sent to, I think, to Reichman's email and to Kathy Griffin's email, perhaps somebody else, but I don't recall. But it wasn't sent to Fatel. And I got a response back from Fatel within a short period of time, which led me to believe that the person who received the email contacted Fatel. So a bunch of stuff is sent out to the GTII people in New York. And by the way, there's no office. It's just literally it's a email address, but they didn't have an office. So one of the confusing things that we had in this whole issue was they bought a bunch of office furniture. So I don't know what you do with the office furniture if you don't have an office. It makes it kind of a difficult situation. But be that as it may. So I'm hearing from a bunch of people, then I reach out, I'm not getting a response. So I'm getting annoyed at some point in time because I'm trying to resolve this entire thing. So February 6th of 20, so I'm starting late, probably the last quarter of 2023. I don't remember when JR kind of told me about it specifically, but I've reached out, and finally February 6th of 2024, so that's about 15 months ago, I reach out, send it to care of Global Tech Industries Group, GTII, care of David Reichman, CEO, Kathy Griffin, president and board member, and counsel Warren R. Markowitz. I spoke to Markowitz, I believe, once, maybe twice. Once might have been about the dividend, and once about something a little more serious with regard to this. But I don't think I had ever had a substantive communication with him. But I thought he was counsel, so I included them in this particular email. So this is where it starts, and it's regarding, and I'll read some of it, I have a few of them. They're not super long. I'm going to read some of it, so you just get a little flavor of what I was trying to accomplish, what I was suspecting, and how they kind of blew it, in my opinion. And just understand, everything that's contained within the receiver's reports, motions, I knew nothing about. So it was only kind of what people generally told me, my dealings with these guys, and my own intuition, probably dealing with some fraudsters in the past, that led me to the conclusions that I knew. And if I would have known what the receiver knew, I would have been much more strong in my language. But it just goes to show you that that a lot of people had issues, and to me, even though I didn't know the facts, I knew there was something up. So I wrote to these guys, dear madams and sirs, I am a GTI shareholder and have been approached and discussed this matter with others and other counsel. Before I take and coordinate further action, I thought it worthwhile to reach out one last time. So that's why it leads me to believe that I had reached out, or else I wouldn't have said that. Again, this is February 6th of 2024. I realized that, in fact, that GTII is an incubator for other opportunities. GTII, without any significant income or engagements, has been dramatically targeted by short interests, some of which were deemed to be illegal. Notwithstanding attempts to isolate Alpine, the shorts, without any story of future value being presented by management, have continued to target GTII stock. The share value has continued to dip lower. As a result of your inaction to make the business work, my stock value and that of others has plummeted to just over 20 cents per share. I'd love, by the way, if it was 20 cents per share. My understanding is that top management, and in particular the CEO, perhaps to retain some level of control, contrary to his fiduciary duty to shareholders. And again, this is just my opinion based upon what people are telling me. I don't know all of the bad conduct, but I'm just getting the bad feeling. I'm getting nauseated, literally, by what I'm hearing. Has not only turned down several viable and valuable deals that would benefit shareholders, but recently the named GTII individuals, those people I mentioned before, on this letter received share distributions, further diluting the interests of shareholders like yours truly. And that was, if you recall, I think in the beginning of January of 2024, it was discovered that they had issued a bunch of shares. There was like 65 million shares issued one day. I think part of those were canceled. Part of those, I don't know what happened to them, but it seemed odd and it was excessive. And, as the receiver would probably say, they were issued under dubious circumstances. But I just became aware of that, and so I brought it to their attention. We do not believe there was full disclosure provided in light of management's refusal to engage in combinations or other transactions that benefit shareholders and the apparent control issues. So I'm kind of explaining, I'm at this point in time, I am pushing because I've heard about all these prospective transactions. Just to give you an idea of what I was thinking at the time. I'd heard about all these transactions, and I'm basically getting them to poop or get off the pot, kind of move this. Then I talk about Delaware and that what happened to Elon Musk, and I suggest that if they engage in shenanigans, then perhaps all their stock or options can be undone, like the Delaware court did. It appears to me factually, especially in not engaging in good faith negotiations on prospective business dealings, because that's what I had been told. And I guess what the receiver said is there was a history of they would enter into negotiations with a business, they'd do some letter of intent, and then they wouldn't close the deal. And there may have been sales of stock during those periods of time. So anyway, let me read that paragraph again. It appears to me factually, especially in not engaging in good faith negotiations on prospective business dealings, that there has been a complete violation of the named party's fiduciary duties owed to shareholders. We do not know if the named parties financially benefited. So at that point in time, I didn't know if they had financially benefited. The receiver certainly claims they did in not proceeding with viable transactions for GTII. But should this matter need to be litigated, we will seek to pursue all entities and personal financial records to complete a full accounting. I then go on, etc., and I give them like the 26th to kind of bring me up to speed, or I'll take further action. And I threaten legal action, seeking special damages, punitive damage, removal of the officers and directors. And I said I gave them till 2/26. I think what happened, and I don't hear from them, but I think during this period of time, I hear from somebody who also was on the auditor's list of people who didn't certify. I think his name's Robert Hantman. I think he's an attorney in New York. He had, I think, according to the receiver's motion, there's about 360,000 shares that the receiver would call illicit. Anyway, I believe prior to the 26th, I'm contacted by Hantman as an agent or representative of GTII or Reichman. He kind of suggests for me to hold off because something's up, or something may be up that's positive, that might further things. I capitulate, so I wait. I wait a few days, and Hantman also, in general, we had some discussion. I think he didn't say anything too particularly favorable to Reichman, is my recollection. And then at a subsequent time, he called me or emailed me inappropriately, because it wasn't supposed to be me. I called him back, and he didn't remember speaking to me. He didn't know who I was. Now, what's interesting about that, so that inappropriate or communication from a lawyer who was a shareholder of GTII, who was affiliated with Reichman, who hasn't signed off that certification, but sent me something he shouldn't have sent me. And then at some time in 2024, just ironically, Kathy Griffin did the same thing. Kathy Griffin was an officer or director of GTII. She did the same thing. She sent me a communication that was intended for Reichman. It was an email, so it was hard to avoid. I erased it and sent it and advised her. But it was, basically saying something to the effect of, can you shut Hoffman up? He keeps on talking about you. Something like that. They then filed, ironically, is there a problem with that? The communication, and then the exact language, we can't shut Hoffman up, but it was essence, that was the message. And then a defamation action was filed, which was dismissed eventually also. But it's interesting, is there, some issue there about some improper agreement? But anyway, she sent me something that she shouldn't also. So it was two people. So besides all the shenanigans going on internally, it looked like they were out of control and couldn't do anything. Hantman reached out to me, said, could you hang on? I agreed, because I had no interest in pursuing a lawsuit against these guys. I was hoping to get them to do a transaction. That's what I wanted to get done, because I wanted GTI to go forward. And if in fact there was a short position and there was a transaction, then maybe there would be a squeeze if that was going to happen. Again, I didn't know if that was going to happen, but I thought if a business came in and there was some kind of transaction, if there was a concentrated short position, and I know Ham believes there was, and the DTCCCC says there was, then maybe there was. So then March 3rd, 2024, again, it's quite a bit of time ago, I got a short letter from Fatel, the attorney. He says, and I don't know who we are, it's Fatel Legal PLLC, but it's Jack A. Fatel, who is the attorney who I spoke with and communicated with. Dear Mr. Hoffman, we are counsel to GTII, and we're writing in response to your letter dated February 6, 2024. So it only took them a month to respond to the letter. They basically say under federal securities law, they can't speak to an individual shareholder, but they do, but they can't. And then they say, you allege that GTI's, just listen to this. Listen to this in light of the fact this is March of 2024, and listen to this in light of the fact that the receiver's reports, the fourth report we went over in the most current motion, and listen to this because it's short, but it's kind of funny in a way. You allege that GTII's management has omitted to make business work. The reality is that management is continually striving to resolve any issues and advance shareholder value in good faith and with dedication, while prioritizing shareholders' interest. Understandably, it is in the best interest of all shareholders that GTII complete a fruitful transaction. Furthermore, GTII is working towards closing its outstanding acquisition target as soon as possible. As you can understand, the acquisition target is a separate legal entity not yet controlled by GTII. We ask that you await GTII's upcoming 10K annual report for important details that will be made available to all shareholders. Thank you for your patience. Signed by the attorney for the GTII. Now, he starts off just kind of like, listen, humor me on this. He starts out saying that he can't really disclose it because he can't disclose it to individual shareholders, but then he does. And he denies that they're not operating, basically, they are trying to make the business work. They're striving to help, and they're looking out for shareholder value in light of the receiver's reports. I mean, unless, let's just hope he didn't know. Let's just hope the attorney didn't know and he was just blind and had no idea what he was talking about. So let's just assume that he was just making it up and didn't know it was what was going to be in the receiver's report. But the argument that management was working to advance shareholder value, I guess it could be true if you're only talking about the senior management and none of the real shareholders, the other 15,000 shareholders. But if you're trying to suggest that it's in interest of shareholders, this is false. This is just not true. So either he didn't know or this is a falsehood. Now it's a disclosure to a shareholder. So is that a disclosure to a shareholder that would be subject to securities laws? Because he told me that at the start. I would think so, but I'm no securities lawyer and I don't know, but that's what it would lead me to believe. If somebody's talking about basically management and the way they conduct their business, and then they talk about the outstanding target, the last paragraph. They're in the process of basically closing a deal. And that's what he represented in conversation also. And this is March of 2024. As far as I know, no deal was in process, certainly no deal closed. And then he refers to the 10K that was going to be filed. And they said it was going to be filed no later than March 31st. It wasn't filed on March 31st. And when it was filed, it doesn't talk about an acquisition being concluded or being in process. Not at all. In fact, I think the receiver in his recent objection refers to the very last transaction that was referenced that management didn't do. Again, the receiver says there was a bunch of these. I think the receiver alleges also, you can check me on this, that it may have been some kind of scheme to take advantage of the volatility by senior management. They would, the stock would go up in value when a deal was on board, and then they would sell, and then, et cetera, rinse and repeat. But the reference to the 10K, which wasn't filed, the reference to the acquisition, it didn't happen, the reference to making the business work and management was continually striving to advance shareholder value in light of what went on is false. And it's a representation. In my opinion, no securities lawyer, but wow, this is not a lawyer to lawyer. This is me as a shareholder. I started off. If you recall my letter of February 6th that I send to the company. How do I start off the letter? I am a GTII shareholder. That's how I started off. So he's sending this to a GTII shareholder. I know that the management must know about it also. So why didn't they prevent this if this was a falsehood? Because to me, it appears based upon what the receiver says that these things are not true and correct. And again, it can only be that they didn't know and just kind of wrote them, or did know, and that's a bigger problem. But I think it's a securities issue, just in my opinion. Again, not being a securities lawyer, it's a discussion with a shareholder about significant issues that might affect value of GTII at a time GTII was still able to be traded. So anyway, so March 10th. So there's still some interaction. I think I'm getting annoyed because I'm getting like contrary stories. So somebody tells me one thing and somebody else tells me another thing. Sunday, so you could tell I'm working on this stuff, have been. Sunday, March 10th of 2024, I emailed Fatel, and and we talked about a conversation we had that day. I don't remember if he was in New York or Montreal or where, but somewhere in a different time zone. Dear Mr. Fatel, this will confirm our conversation on Sunday, which is that day, at about 12:30 p.m. Pacific time. So I sent this email like 12 minutes after the call. You reassured me of GTI's efforts to close a transaction without specifically identifying one. So he tells me that they're working on closing a transaction. Couldn't guarantee it, but he was basically saying they're making progress, etc. And I wanted to document that, so I did. And I was threatening to take legal action because they hadn't really been cooperative, except for his March 6th email that I just mentioned. In light of our discussion, I volunteered to not take any legal action currently, but I'm not waiving any rights. As I indicated, and so here's the bottom line. This is what I told him March 10th of 2024. I think this is prophetic. As I indicated, I am going to go forward and hold management's foot to the fire, reconsummating a transaction, as I mentioned. I also indicated that my conversations with GTII's new consultant, I think I was referring to Mr. Rabari at that point, was disappointing to say the least. I'd reached out to Rabari and he didn't seem to be interested in the short positions. And I think the receiver is also going after his shares, but I don't know what he specifically did at GTII, good or bad. I don't know, because I didn't have any discussion with him other than this one discussion. I think he was driving. I was speaking to him while he was driving. And again, he didn't seem interested in the short position of the company. And I'm unclear if he really knew what was going on. I don't know. And then last, however, your reaffirmation of GTI's efforts and intention regarding moving forward on material acquisition gave me comfort. So this is what he says on the 10th. Then on the 11th, I indicate, because I remember it, he also mentioned something that caught my attention in our conversation, and I remind them and ask them a question. In our Sunday conversation, you vaguely referenced small entities not always following all corporate requirements. Did you have something in mind? So I sent it out to him early on March 11th. And what he had mentioned was he was doing cleanup, that there was stuff that the management had not done properly. And part of his engagement was engaging in cleanup. He didn't specify what that was, but that's what he was referencing. And then, without getting into a lot of other communication, I found one more, and this is kind of like the coup de grace. So I haven't got any satisfaction. There's no, information about a target. They didn't file they hadn't filed. I don't think they had filed, or just they were late in filing the 10K. When they filed the 10K, it was really had distressing information. So what I do is on April 17th, address to Markowitz, to Fatel, Reichman, Kathy Griffin, I write, and this is the last one we're going to talk about tonight, and you can go to Sleepy Pie. Dear sir and madam, when I started on all this, all I wanted was for management to get out of the way and not to continue, in my belief, to loot shareholders. After reviewing the 10K, which they filed, which was replete with typos and seemingly false statements, I was pissed and shocked at the level of dishonesty and grift. I can guarantee, so here it is. I'm saying this April 17th of 2024, and now you could see where we are today. And you could see, for some reason, they just didn't take me seriously as they should have, as it appears where it's headed. And I wrote in bold, I can guarantee it will not end well for those who this notice is directed at, as well as others who are not referenced, who either played a part in the scheme or benefited personally from it. And as we sit here today, more than a year later, I think those words will live to haunt everybody on that list, I believe, if in fact the receiver's investigation and conclusions are correct. And we will see if any of these people have the composure to, under penalty of perjury, argue that they're entitled to shares, they got them in good faith, that they weren't under dubious circumstances. I go on. Soon this will be out of my hands, and the ramifications you all will be facing will not be in your or my control. Without getting into the substance of the totality of the unprofessionally done 10K, replete with errors, and there were errors in it, even after a misrepresented delay, again, because they told me it was going to be filed at a particular time and it was not. Here are 3 points that struck me. And this is kind of interesting, again, in light of what the receiver's fourth report said and his most recent motion. The reference to the delisting in the 10K by the OTC in April 2023, concealed and suppressed by GTII management and counsel for almost 1 year, based on inaccurate disclosure, insider transactions, sounds like an admission of insider trading or worse. Obviously, I and others will subpoena the OTC markets and get to the bottom of what caused them to delist GTII and why it has not been rectified to date. If you recall in the receiver's most recent report or in the motion, they reference that, or I think it was in the report, the fourth interim report just came out. They referenced this related to the distribution of shares involving, I think it's .8, and involving the Reichman's family, insider representations by other officers and directors. And that's what wasn't clearly disclosed by GTI at any point in time. It was only through the receiver's report that we saw the reason for the downlisting to the pink sheets. And why is that important? Because when they got downlisted to the expert market later on, because they didn't file their financials, if they hadn't been downlisted to pink sheets, perhaps they wouldn't have been put to expert markets and it would be tradable. So I talk about potential insider trading. So to the extent there have been improper transactions as referenced by the OTC, besides whatever remedies others seek, I and others will seek the disgorgement of any and all stock, proceeds, monies, securities, and any and all property that arises out of the actions that cause the OTC to dump GTI to pink sheets, all of it. And again, I think as of this point in time, we hadn't been kicked off down to the expert market. Even though you intentionally tried to bury, and this is all my opinion, of course, but according to the receiver, my opinions were pretty on the money, even though I didn't know the facts. The facts were much worse than my opinions. Even though you intentionally tried to bury it in the 10K document, your failure to disclose it for over a year, during which time the stock tanked, in my mind, besides insider trading, constitutes security fraud done intentionally. This is all in the public, and shareholders are angry. And I do remember that. People were upset. A lot of shareholders were upset. Once that financial came out, that was hideous. And okay. And then I say in bold, and I welcome anybody to join in if they are on the bad team, but they want to be immunized to any degree. Reach out to me. Reach out to the Receivers Council. As I've said before, whoever rats out senior management first will get a full release from me. And as you recall, I'm going to be representing myself in the Vegas action, hopefully starting this week, because we have a hearing on it. I think it will be granted. I know counsel has a duty to withdraw if they become aware of potential criminal misconduct that their client is undertaking. So, I'm sending this to 2 attorneys, and I don't, besides the issues with the securities issues, I'm wondering, that's what I'm doing. I'm wondering. As to the financial statement of GTII in 2023, it clearly appears that at the time it was decided was short. So what I'm saying, in 2023, someone finally decided it was time to steal some money from the company in these final days. And you all still had the balls, notwithstanding my direct warning, to continue to sell stock yesterday. Yeah, they were still in a stock plan, a stock sale plan. So even though I told them don't sell stock, You shouldn't be selling stock. They continued to do it, and they ignored my warning. Each and every one who stays at GTII knowing 1 and 2 acts at their own risk from this point should hire independent counsel and is without any empathy from me. Where is the extra $4 million in cash that was suddenly used in 2023? So I'm asking questions. I give them the opportunity to respond, by the way, and at no point in time do they respond with any answers. Some counsel offered, so next point, somebody offered an opinion about the issuance of a dividend. How could they have done that if they didn't talk about the issue about the money and everything being issued, all the stock being issued and the other issues? Last, and I'll skip the last part. And then I criticize Reichman's ethics. Last but not least, so this is April of 2024. So notwithstanding, I didn't know Jack at this point in time. I actually knew Jack Smitty, but I didn't know the specific facts. But I knew there was stuff going on. Why did I know that was going on? Because a bunch of people tell me, because the lawyer had kind of misled me, because the 10K was late, because there was no acquisition, because the financials looked terrible, because there was mistakes in the financials. I don't think Borgers had been kicked out yet. Borgers, the CPA, I don't think they had been downlisted the expert market, but still, I said, it's not too late to avoid all the ramifications, plus others, that your actions have caused. However, if your oversized ego will not let you take responsibility for your obvious misconduct, then all responsible and all those not named who received benefits will all go down in public embarrassment with whatever other remedies that others impose. Finally, do the right thing and get out before it's too late, and that is a warning to everyone associated with this disaster. By now, you should get that I mean what I say. If you want to continue to test me, it will not end well for defendants, their associates, and for all who personally benefited from the misdeeds. I would much prefer that this ends quietly, with all at GTI leaving out the back door in resignation. A very pissed and angry Richard Hoffman, shareholder. So April of 2024, I didn't know the facts. I gave them the opportunity to get out. And there's plenty of communication. The only communication I got back was either miscommunication or no communication. They dug their own hole. Knowing now it's in receivers' reports, now perhaps we understand why they dug their own hole. So I just wanted to let you know they had an opportunity to escape. This goes back quite a long time. My nose was good. My spidey sense was good. But again, I didn't know the facts. They knew the facts. Them knowing the facts, there's no reason they shouldn't have gone out and cut a deal. Last but not least, related to Alpine, I found, because I always look, and it's always interesting to me, is I found, we've recently found whoever again we is, we QUI, or in French, yes. Recently, I found something that Alpine Securities did a deal on behalf of Vocodia, who had some minuscule market cap. Minuscule, I mean that the market cap of Vocodia was less than my desk. But anyway, I don't know what specifically Alpine was going to do for it. And this is a recent time. And it's after Alpine had been, got in trouble. So this company apparently hired them knowing that. And today I found another one. And the name of this company is called Mineralite Corporation. The ticker symbol apparently is RITE, and it's in March. It executed an investment banking agreement engaging the services of Alpine Securities Corporation. Again, the regulators are permitting Alpine to still engage in business. I don't know why anybody, maybe they're great at what they do. And maybe that's why companies like RITE, RITE, engage their services. Perhaps that's it. But, if you looked at their history of discipline and what their current status, you don't have to look at the past, just look at the current status, all their expulsion proceedings, multiple through multiple regulators. And then we get to the conclusion: why hasn't FINRA or the SEC intervened? Because theoretically, if in fact Alpine is engaged in misconduct, aren't the regulators giving them another opportunity to screw somebody else? Isn't that the issue? If in fact the regulators believe that Alpine has screwed all kinds of people and the public at large, why are they letting them continue to operate? Again, I'll repeat this 100 times, and since GTII is the perfect example of it, put them in a receivership and put them out of business. If they have engaged in misconduct and the public is at risk, as FINRA and the SEC have said, it is inexcusable to let them continue and not at least try to put them in receivership and take over the operation, the business, to protect everybody. So that's something I found today, kind of shocking. That's a Dallas, Texas company, by the way. If anybody knows about them, I'd be interested to hear about it. So we went over the very early days of the GTII issue, how I kind of gave them the opportunity to come clean, how the representatives of GTII were not, let's say, absolutely crystal clear and forthright in how they communicated, and they let it get to this point. And I told them more than a year ago that it was going to end bad. They just didn't take my not legal advice. If they had taken my not legal advice, we wouldn't be speaking today on this holiday. So anyway, I thought it was interesting. And again, it was brought up to my attention because I remembered the attorney Fatel, since he didn't sign the certification and he's at issue, I wonder why he didn't sign that. I do remember interacting with him. And again, the other person that was also hadn't certified the audit was Hantman, and he also engaged with me. So because of that, I wanted to go back in time to kind of relate to you kind of the early days and to disclose to you that these guys could have gotten off. They would have to return shares, money, etc. But if they had handled this in an appropriate way, we wouldn't be talking about this. Perhaps we would have been way down the line. The stock probably would be worth a lot more, wouldn't be delisted. Everybody would be, hopefully in a better position. Everybody would be in a better position. As a result, I don't think any of these defendants are going to be in a better position. And if it worked out, perhaps we will, if the deal with AI Versity goes through, or then I think that we will certainly be better off than we were with no deal going forward. Anyway, just thought you guys might have interest in that. I hope you guys got something out of that or enjoyed it. If you didn't, then I apologize and I wasted your time. And if you did, then that's great. If you have a comment, joke, put it in when I'm going to post the video. I presume there's some people that came out here tonight. I appreciate everybody's watching this live. There are more than I thought, a lot more than I thought. But to those of you who see it later on, I appreciate you watching it. If you have specific questions, put them in there. Again, I look at all comments. I may not respond with a reply, but I look at them all, and usually you'll see some indication that I have looked at it, because I might start or something like that. To all of you out there who stood here and came and hung out, I appreciate it. Always enjoy spending time with you. This coming week, we have court hearings, and I'll report about that, and we will go from there. Be well, take care, have a great evening or morning, and see you soon.